Thank you, Mr. Chair. I have a couple of questions for the author and then
Go ahead.
Representative Gottwald, I'm wondering if you recognize a distinction between religious and civil marriage.
Representative Gottwald.
Mr. Chair, I wonder if Representative Hortman could clarify. Did you say, do I recognize?
Yes, Representative Gottwald. Do you recognize a distinction between civil and religious marriage?
Mr. Chair, Representative Horton and members of this committee, I would remind you that the measure before you is a question to be put on the ballot in 2012 regarding a constitutional amendment. I'm not sure how that's germane to the bill, but I believe there's been testimony here today that has indicated that this is both a civil and religious matter.
Representative Hortman.
Representative Gottwald, do you believe that the Catholic Church is obligated to recognize all civil marriages?
Representative Gottwald.
Mr. Chair, Representative Hortman, this isn't about my beliefs.
Well, Mr. Chair, the reason I ask these questions of Representative Gottwald is that in support of his bill today, he's brought people to speak on behalf of their biblical traditions and their different branches of Christianity. And they have put forward a reason for us to adopt this amendment and put it on the ballot, that this is a biblical definition or a definition of marriage that's consistent with the Torah. And so I think it's really relevant whether the author of the bill recognizes a distinction between religious and civil marriage. Because, Mr. Chair, I do recognize a distinction between religious and civil marriage. And I'd like to talk about the issue of civil marriage, which is the only one that we as state representatives can have an impact on.
Representative Hortman, we can discuss your beliefs. I would ask you to not go down the road of questioning individual members' motivations, and we'll focus on the bill at hand.
Thank you, Mr. Chair. I'm not questioning motivations. I'm just questioning the legal status and the understanding of the two different institutions. The civil institution of marriage, some have said, is this inviolate thing since time immemorial, has been between one man and one woman. And I would just like to point out that the civil institution of marriage has evolved over time. What the civil institution of marriage used to be was a transfer of me from property of my father to be property of my husband. And the civil institution of marriage used to not allow me to own property or convey anything in my own name. Not until 1848 in this country did I have rights in any state to legally transfer property as a married woman. So that the definition of civil marriage has evolved over time, and thank God that it has. I think that we should vote this proposed amendment down today. I don't think it should be put to a vote of the people of Minnesota because marriage is a fundamental civil right. And the Supreme Court has held that in Loving versus Virginia and Griswold versus Connecticut. At the time of the decision in Loving versus Virginia in 1963, the same reasons were cited for forbidding interracial marriage as are cited today for forbidding same-sex marriage, that God was against it. And I think that history won't judge us kindly, just as history would not judge these folks kindly in the past. At that time, it was represented that Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. All but for the interference with this arrangement, there would be no cause for such marriages. That's what apparently the Almighty God was saying in 1963. In 1967, the Supreme Court, however, ruled unanimously that marriage was a fundamental civil right. It was fundamental to our very existence and survival. They stated that to deny this fundamental freedom is surely to deprive all the state citizens of liberty without due process of law. Under the Constitution, the freedom to marry or not to marry a person resides with the individual and cannot be infringed by the state. Mr. Chair, members of the committee, I appeal to you not to put the question of fundamental civil rights on the ballot for majority vote. We've already heard from the legal expert from the University of Minnesota that if we put women's rights up to a vote in an earlier time, it wasn't so very successful. If we put African American rights up to a vote in an earlier time, it wasn't so very successful. And ultimately, it's the court that interprets the Constitution and preserves for each one of us our civil rights. It is not the majority vote that gets to decide what my civil rights are. And so, members, I think this is really a call to conscience. I know this is a difficult issue, but I hope on the grounds of the 14th Amendment of the Constitution and the Supreme Court authority in Loving versus Virginia and Griswold versus Connecticut that members will vote no on the bill.